So I know this slide may seem a little bit daunting, but it's very important to know that there are laws in place that state that it is illegal to knowingly hire unauthorized workers in the US. So IRCA requires employers to verify that every new employee is legally authorized to work in the US through the I-9 system, which is what every employee needs to fill out. However, there is an exception which says that an individual or entity is not required to obtain Form I-9 from independent contractors. So as I shared before, independent contractors complete the W-9 form instead of the I-9 solely for the purposes of paying taxes. Even though entities or individuals are not obligated to verify the work authorization of individuals whom they engage as independent contractors, the federal statute listed here prohibits an entity from knowingly engaging an unauthorized individual to provide services as a contractor. This means that if an employer is aware that an employee's work authorization has expired, he or she could not then contract with that same individual as an independent contractor. Therefore, if a DACA beneficiary were to lose his or her work permit, the company that hired them would not be able to contract with him or her. So really the focus on this is the knowingly part. And the knowingly part refers to having a paper trail of some sort that shows evidence that the person lost work authorization. So people such as doctors, lawyers, graphic designers, artists who follow any type of independent trade, business, or profession in which they offer their services to the public are generally not considered employees. The general rule for being an independent contractor is that the payer has the right to control only the result of the work and not what will be done and how it will be done. It's extremely important for you and your potential payer or client to understand the rules and differences between an independent contractor and an employee. Misclassification may result in legal consequences and penalty fees incurred by the payer or the client. To determine whether an individual is an employee or an independent contractor under the common law, the relationship of the worker and the business must be examined through the IRS common law rules, which are behavioral controls, financial control, and the type of relationship. So I'll go over these in a little bit more detail. So behavioral control includes facts that show whether the business has a right to direct and control how the independent contractor does the task for which the independent contractor was contracted to do. The key consideration is whether the business has retained the right to control the details of the independent contractor's performance or instead has given up that right. Financial control includes facts that show whether the business has a right to control the business aspects of the independent contractor. These include things such as how a worker is paid, whether expenses are reimbursed, who provides the tools, supplies, etc. The type of relationship includes facts that show the party type of relationships such as written contracts, financing of benefits, permanency of the relationship, etc. These common rules are discussed in much more detail in the IRS publication 15A 2016 edition. These guidelines are intended to protect workers from being exploited. Employers who hire employees must pay for some taxes, benefits, insurance, etc., whereas the independent contractor pays for these costs, saving the organization or company money.